continue on this wonderful, fun subject of closing out a contract. And I've mentioned a couple times about run-out provisions, and now we're going to be just a little bit on specific types of run-out provisions. And as we mentioned before, the typical types of run-outs, warranties and guarantees, requirement for preventive maintenance, requirement for repairs, requirements for records. Let's see. As discussed in planning, for some run-out procedures, contractors are paid when the procedures are performed. And it's easy, relatively easy, or easier to deal with performance issues when you actually are going to make payment, so that if the vendor doesn't do something, you don't pay. And if they want to get paid, they do it. So that is the incentive for them to do it. It's more difficult when they don't specifically get paid, and how do you require performance or help assure performance if it's not something they're getting paid for? And if it's a warranty and and that's supposedly embedded in the price, and so you're not making an extra payment for warranty, and something goes wrong and you have to go back to them for repair or replacement and they don't do it, well, there's no additional money to withhold, so what do you do? That's where it becomes more difficult. The retention of records. If you go and request a record because your auditors want something, and when you request it they say, I don't have the records anymore, and there's no payment, how do you enforce that? That's where the issue is. How to obtain performance of the run-out procedures when there is not additional payment, or even ones when additional payment be made, but the contractor, and this sometimes happens, may not have retained the capability to perform and or deems the payment to be insufficient. Maybe they even quoted a price, but now, years later, well, I don't want to do this, I'd rather forego the payment than actually perform what I'm supposed to do for that payment. So we're going to discuss that. There may be a requirement for the contractor to appear, and these are examples, to appear at administrative hearings or in court to provide testimony for 2 or 3 years after the end of the contract if there is a suit filed concerning the contractor's work product. The only way to know if the contractor will actually comply with this requirement is if you call upon them to provide that requirement, to actually provide testimony in court. So if and when the contractor is called upon to provide testimony, the contractor might say, well, gee, guess what? I know we were supposed to retain all of our work papers, but we're looking through the files, we can't find them. What do we do? Or, well, all the people who worked in that contract are gone. They're either been transferred elsewhere in the company, or they've left the company, they retired, whatever the situation. So we can't provide anyone who actually had hands-on experience with that activity. And in addition, we can't find the papers. So yes, I know we're supposed to come and provide testimony in court, but gee, do you really want us to come and have somebody who, when the lawyer for the appellant asks, well, did you personally work on this? Well, no. Well, why isn't the person who worked on this here? Well, the person's no longer here. Well, to what degree do you have personal knowledge of the issues at issue? I don't. Well, did you acquaint yourself with the issues by going through the file? Well, we couldn't find any. And so that doesn't make a very compelling witness. So if there's the requirement for the vendor to do this to help the state if there's some kind of issue with the state having to defend something, and the bottom line is the contractor does not help the state's case at all, do we have an issue? If we're going to pay them more money, maybe we don't pay in this situation, but if we weren't going to pay more money, we have nothing that is of value, and what do we do? So what you're talking about is the vendor should be reminded of the contractual requirement, and that the failure to perform will have serious consequences if it seeks another state contract, the old threat routine. It's like a senior DHMH person many, many years ago, that every time we'd be discussing something and he would say something needed to be done, and someone would come up and say, well, what happens if it isn't? And his stock answer was, bad things. And we'd say, well, such as? such as bad things. And that was the only answer he ever gave, and he would put great emphasis on it. He would get very emotional, and he'd start pointing, bad things. Well, very bad things. But you could never get a specific out of him. And it's because usually it was just, if we make enough of a threat and enough of a bluster, hopefully no one will ever test us on what the bad thing is. So we're kind of in the same situation. We have to kind of threaten them that, well, now that you have proven unreliable, that if you seek the same type of contract, it's going to have consequences, because we know that in the final analysis we couldn't depend upon you. So the lack of performance could result in the vendor being deemed by the agency as not responsible if it sought a future contract, in the agency informing other state agencies of the non-performance, which could mean the inability to win other state contracts, in the agency filing a claim against the vendor for the cost of any adverse decision because it did not provide testimony. So these are the things you could threaten them with. These two we've talked about before in terms of the experience with other state agencies, the 5 years of other contracts, that type of thing. This one is where, again, we couldn't have filed a claim previously if there wasn't a lawsuit, and it was only when there was a lawsuit that we go to get the vendor to perform that we find out they're not performing. Now we have a basis for the claim potentially that if we lose a case because they can't defend their work, which we relied upon to begin with, then maybe we're going to file a claim to say we're going to have you pay up the judgment, or at least some part of it, because you couldn't defend when it came to that point. So that's a possibility. You'll have to talk to your attorney as to how viable that is, but the very possibility you threaten it may be enough to spur a vendor to try to do something. Let's see. The same answers would apply as listed for when the contractor said it lacked the capability to perform. So the one thing is where it doesn't perform. Let me go back. No longer has the capacity. Let's see. When they don't get paid. So when they're paid but don't have the capacity, they're basically saying, I can't do it even if you don't pay me, I can't do it, so you can withhold the money, and that may not be good enough. And when we don't pay them, you basically have the same answers. It comes down to threats of not selecting them the next time. And if that works, fine. If it doesn't, then you follow through, and if it seems appropriate, you don't select them the next time. So that's what you do. You make threats of bad things happening. General assessment. We talked for a second day, something like that, about that you could do a vendor report card. You could do it every 6 months or annually or something like that. At the very least, excuse me, what you want to do at the end of the contract is to have general assessments, so that now that the whole thing is coming to a close, it isn't an interim, it is now for the final statement to be used in the future, for improving performance, for using in the future. If your agency, or if another agency comes to you about how a vendor performed, you're going to have something in the record that will be available to look at to gauge that vendor's performance. So the general assessment will be of the contractor's performance, that what we've been talking about specifically, of the state. You also want to assess how you did. Did you apply the proper resources? Did you have the correct contract manager? Are there things that you should have done that you didn't do, that in the future you realized that they were the reason why you got subpar performance? So you want to make sure you have that taken into consideration. Did you close out the contract properly? And using these two things, what do you want to change in the future? So that all should be in a general assessment report that is in the contract management file that you retain for future reference. And we have a non-existent exercise. All right. So now we're going to come to another wonderful little circumstance that happened in the many years in the past. In the early 1980s, and this is where you come up with actual situations, and when you try to go back and reconstruct, you find out that you don't have the basic information, so you're left with what do you do? And these are the things you try to avoid. Early 1980s, there were a number of housekeeping contracts at DHMH facilities. At this time, there were housekeeping contracts. At this time, housekeeping was defined as a service. It wasn't until 1996 that housekeeping became construed as building maintenance, so it was a service up until then. Each of these housekeeping contracts were procured via competitive sealed bidding and had two pertinent aspects. Number one, the number of weekly direct and supervisory labor to be provided was specified. And what that means is, in the specifications, we specifically said, you will provide 180, 200, 320, 400 weekly hours of direct labor, and you will provide a certain number of supervisory labor. And the example up here was 320 of direct labor, or the equivalent of 8 full-time personnel, and 60 hours of supervisory, like 1.5 supervisors. And I remember when I first came to DHMH in 1979 and immediately became working with housekeeping contracts, I asked my boss at that time, why are we telling the vendors how many hours they should provide? And he told me, because that's the only way you're going to get the contracts performed properly. And what he told me, and I said, well, how do you know what is the correct number of hours to specify? What is our magic knowledge? And he said what he did was he went to 2 reputable vendors and that he used and knew and trusted, and he asked those 2 vendors to give him their assessment of what it would take to properly do the job. And he would take those 2 responses from vendors that he trusted and somehow either take the difference, or somehow he worked out from those 2 responses the number of direct hours to specify and the number of supervisory hours to specify. And since I had just been hired and was working for him, I said, yes, sir, okay, no problem. The other thing that was specified, so the one was how many hours of this type of labor, how many hours of that type of labor. The other thing was standards of cleanliness. So they were pages and pages of what the place had to look like. The floors had to be cleaned, the carpets had to be cleaned, the restrooms had to be cleaned, the trash cans had to be emptied. Everything was specified as to what was a clean facility. I.e., even if a vendor provided the specified number of direct and supervisory labor hours, if the cleanliness standards weren't met, the vendor had to provide whatever level of effort was needed to meet the standards. So we had 2 conditions: meet the standards and provide X number of hours. And if you provide X number of hours and the standards weren't met, you meet the standards, regardless of what it takes. Now, what we didn't do was the opposite. What if you meet the standards, but you don't need the same number of hours to do it? Because it was assumed that it couldn't happen. DHMH had procured housekeeping services like this for many years, and then, lo and behold, once upon a time, a disgruntled former employee of one of the housekeeping contractors did a whistleblower. And they contacted the Office of the Attorney General, and what they said was, my ex-employer never gave you the number of hours you specified. They were always consistently under providing the labor, and so I'm letting you know that so you can go get them. The former employee alleged that this vendor never provided the number of hours specified in any of the contracts it held. Based upon this complaint, legislative auditors audited some of the facilities and required the vendor to provide payroll records of the employees that had working at these facilities. So the first thing is, we weren't requiring that type of evidence of payroll records, so we didn't know what the vendor was providing. Or else if they did provide it, we never paid any attention to it. So basically, not a good situation. So now the auditors said, give us the records. These records showed a large shortfall in the number of employees, i.e. the labor hours provided. Based upon these results, at a couple facilities, the auditors went in and audited every housekeeping contract that DHMH had. and the results were consistent. The results were consistent. All vendors were providing significantly less than the specified number of weekly hours, sometimes as much as 40% less. So if you're providing only 60% of the number of hours, you're getting paid the same amount that you quoted, but you're not providing the hours. But the other part, in all instances, DHMH facilities were satisfied that the standards of cleanliness were met. They weren't squawking, they were okay. They may not be falling all over themselves saying it's the greatest thing ever, but they were giving them reports that said that they were meeting the standards of cleanliness. And there was one facility, and that facility being the Walter P. Carter Center, where the vendor was continually praised because the facility had never been cleaner. And this is one that was, I think, one of the ones that was found to be about 40% less than what was specified, and yet they were getting rave reviews. And the auditors, what the auditors said was, I don't care. They said they were to provide X number of hours, they didn't. Vendors pay the money back. For all the hours of shortages, pay it back. The contracts were structured so that the vendors bid hourly labor rates times the number of weekly labor hours specified to produce a weekly billing total. Example, for the 320 direct, 60 supervisory. Example, if the hourly rate for direct workers was 5 and the rate for supervisors was 8, and at this time minimum wage was a whole lot lower, and minimum wage supposedly actually meant something, and almost nobody paid above the minimum wage for the direct labor, which I found incredible back then, that people were working for $4.75, and if they had even a nickel raise, that was considered a big increase to be paid $4.80 if minimum wage was $4.75. So example, if it was 5 and 8, and if you had 320 at 5 and that was $1,600 per week, $8 for 60, $480, so the weekly billing was $2,080. That is how they came up to $2,080, but they got paid $2,080 without regard for did they provide these number of hours. Although the $2,080 amount was calculated by multiplying the weekly number of hours to be provided times a fixed hourly labor rate, vendors billed the $2,080 amount without regard for the actual number of labor hours provided. The auditors wanted the shortfall in labor hours actually provided to be multiplied times the fixed hourly rate and the resulting amount billed to or deducted from the vendor, depending on whether the contract was still in place or was over. Example, if the vendor who was to provide 280 direct and 50 supervisory, if they provided 280 direct and 50 supervisory, this is where they're supposed to provide 320 and 60. So it was a shortfall of 10 supervisory times $8 means $8 a week for every week it was short would be billed back to the vendor. And they were 40 hours short on direct times $5 equals 200. So if there was a week when they got 280 rather than 320 and 50 rather than 60, the vendor was supposed to, one way or the other, cough up $280. And that for every week of the contract by whatever amount they were short. So, collectively, the amounts to be billed or deducted from all vendors under the current contracts amounted to several $100,000 back in early 80s. The vendors notified of the need to repay the funds said, we don't owe you no money. The vendor, the facility said the place was cleaned. These were performance contracts. We realized that you had specified these number of hours, but no, you and I both know that we didn't actually mean that we had to give you those number of hours, we just had to clean the facility. Such as, if it wasn't clean, we knew we had to give you more hours to get it clean, but we also knew the other side of the equation applied. If it was clean, but we didn't have to give you the number of hours, we still got paid because that was our price to clean the facility. And those labor hours specified, that wasn't a real specification. That was just a kind of wish type thing. It wasn't real. So that's what they said. We don't owe you any money because the facilities were clean. And this was what they said, performance contract. We knew we had to give you more if it wasn't, but we didn't have to give you that if it was. Because why would we give you more labor if the thing was clean? That doesn't make any sense. And we cleaned it. Here's your evaluations that told us we cleaned it. So we got our money because that's what we bid on that basis. And the contracts didn't specifically say otherwise. They had both those requirements, but it wasn't abundantly clear whether both did apply. That even if you did clean the facility, you still had to give us those number of hours, and if you didn't, we would deduct. It was never mentioned because it was assumed it couldn't happen, but it did. So it wasn't clear whether the basis of the contract, whether we were paying by hour, whether we were paying for accomplishment, or just what it was. So most of the housekeeping contracts, coincidentally, were held by the firm whose disgruntled employee was the one who blew the whistle. And so that vendor, even though they disputed the situation, they ultimately, because they were a fairly large vendor, they ultimately ended up paying the money one way or the other to the satisfaction of the state. For the other firms involved, there never was payback. And I remember the vendor, well, all right, let's see. This was I'll tell you the rest of the story before I start diverting a little bit, digressing. Far from the end of the story, based upon this situation, the Department of Budget and Fiscal Planning, which was the predecessor to me, DBM, that's what we used to be called, and when it was still a service under DBFP, required DHMH to bid all future housekeeping contracts as simple fixed price contracts. Kept the standards in, but we stated no hours and simply said you must meet the standards of cleanliness, give us a fixed price, period, to meet the standards. Okay, very simple. And at the pre-bid site visit for the facility described, Carter Center, that I was the procurement officer, I was on the site visit, so these are things that I actually heard. And I heard, as we were going through the facility, the competitors to the vendor who was doing the job congratulating the contractor on how clean the place was. And since many of them, one of them had been the previous contractor and many of them had been there before on site visits for previous procurements, they all said, as the facility had said, we've never seen it cleaner. And when your competitors are telling you, you're really doing a good job, this really looks good, and they meant it. And then, so I heard them do the congratulations, and I also heard one other thing. And two of them didn't know I was close enough to hear. What they said to each other is, it's never going to look like this again. Because what they said to each other is, now this is going to simple, straight, low bid. It isn't going to be like this again. And they were right. The incumbent in particular, this one in particular, objected to the demands for repayment, said it had won the contract as the lowest bidder, which it was. And so it said, obviously, if I'm getting accolades, if even my competitors are telling me that this has been the best they've ever seen it, how can I be failing to have performed the contract? And this was a relatively small vendor, and they couldn't afford to give money back. So they, in particular, contested having to try to give back money when I'm getting praised for what I'm doing. And I was the low bid, so you'd have paid more money to anybody else, and they couldn't have done a better job. So why do I owe you any money? Over the next 2 years, virtually all facility contracts expired and were rebid this way. The result was a 20 to 40% price reduction of all contracts. And I can remember one instance downstairs in this building where we opened 3 different housekeeping bids over the course of, I think, one at one time, a half hour, another one, we opened another one, and a half hour, another one, we opened, later we opened another one. And I think it was Rosewood, Montebello, and I don't remember the third one, maybe Highland Health. And one vendor had all 3 contracts at the time, and they lost all 3 bids. That I could see the representative of that vendor, after the first one, I could see him turn just a little bit unhappy. After the second one, I saw him starting to turn colors, and after the third one, it was like, woe is me. And in each instance, the facility people who were there at the opening were elated, because I remember the one person, I think was from Rosewood, who said, we just made our deficit, because they were paying about $1 million a month for housekeeping, not a year, excuse me, not a month, but $1 million a year for housekeeping services, and the price came in something like 40% below that. And they're saying, we got the budget deficit made. We don't have to go and do all kind of issues now to try to make up for a shortfall. And all that optimism lasted a few months. And within a few months of the new contracts taking effect, then the complaints about cleanliness started coming in. Place isn't clean, place isn't like it was before. These complaints intensified as facilities were inspected by the National Certification Entity, JCO. When JCO would come in and do an inspection, they would often cite housekeeping issues. And specifically at Rosewood, which was the largest facility, the housekeeping was so bad, the one with the 40% reduction in price was so bad that JCO was saying, now you have X amount of time to get the facility clean. When we come back, it needs to be clean. If it doesn't, we will decertify you. And if they were decertified by JCO, they were not eligible for medical assistance, and medical assistance was the primary funding mechanism for the residents of Rosewood. And it meant tens of millions of dollars of, if they would be decertified and lose accreditation, they would lose all the medical assistance funding, which means this $1 million contract for housekeeping wasn't looking so good now compared to losing $10 million because we can't get paid by medical assistance anymore. So and that's when I mentioned to you a couple days ago, one example of when I went out in '89 for Rosewood and did it for the first time as sealed proposals. That was why I did that at Rosewood, so we could get away from simply awarding to low bid, and whatever the price came in, that was who won, and then trying to get performance on that basis. So my answer was go to sealed proposals, evaluate, and that's when I got the vendor who, if you remember my statement, they hadn't bid in 5 years, because when we were bidding on low bid only, as soon as we had gone away from specifying hours, they stopped bidding entirely. And then Rosewood came up and was done by sealed proposals. They submitted. I asked them, why, what brought you to the table now when you haven't for X number of years? And they said, I can see from these specs you're after quality. We're after this. Quality is what we provide. And they did win that particular procurement on an evaluated basis.
So
and they
cancel the other vendor?
How did I cancel? We didn't.
Just let the contract run out?
Yeah. You don't cancel. You didn't cancel vendors. You just let it muddled through as best you could. But my answer was, we can't keep doing it this way, because it was the brinkmanship thing, that you would get to the brink, that you'd tell the vendor, all right, you need to get the place clean or we're going to entertain default. And so what they would always do is they'd come in with intensive effort, they would get it clean at a point in time, keep it clean for a week or so, then things would start to ebb, they'd start to deteriorate again, and you'd have to get to the point that maybe 6 months later you'd give them another threat, and they'd come in and get things up to speed, and that was continual. And the facilities complaining, especially when they were threatened with decertification, and so we went to sealed proposals and did it for Rosewood, did it for Perkins, did it for Carter Center, and maybe one or two others. The big ones we did by sealed proposals, the little ones we still did by sealed bidding, because the little ones were typically in Salisbury and Salisbury, Cumberland, Hagerstown, and we didn't have the same problem, because the vendors who were in those locations were small vendors, they were hometown vendors, and frankly, they were more conscientious. So whereas we didn't have a problem in Hagerstown, we had problems all the time in the Baltimore area. So that's where we did the difference. And result of going to sealed proposals, the result was a relatively small price increase, but a big change in performance. And we're going to give you more details in the sealed proposal class of that particular situation that I've now told you about twice at Rosewood. From then on, sealed proposals was used for all major DHMH housekeeping contracts until 1996, when housekeeping came under DGS. And I remember I'm still chief of procurement here. I go over to meet with the director who was going to be in charge of housekeeping over at DGS. And I said, okay, for about 2 years now, well, no, more than 2 years since it was '89, we've been doing sealed proposals. We'd like to keep that way. And the answer was, we don't do sealed proposals. And I said, but yeah, we have these issues where we need to do sealed proposals, and we've had problems. And the answer was, we don't do sealed proposals. I don't believe in them. And so from that point on, nothing was done by sealed proposals. And fortunately, less than a year later, I skipped town and went down to DBM and didn't have to deal with it. I don't know whether you're still having problems. I don't know. Not that I'm knocking DGS, I'm just telling you what happened. Let's see. Sevilla contract expired, it was redone. So after that, as each was redone, after '96, it went back to being sealed bidding, and costs went down, complaints went up. But by this time, deinstitutionalization was in full swing, and most of the facilities that had housekeeping contracts ended up being closed. So the problem kind of worked itself out. But that's just the story of what happened and the difficulty you can get into when you don't have a clear identification of what a contract is, what the requirements are, what merits payment, what doesn't merit payment. And we had a very sticky situation for probably 6 months or more with, does the vendor owe us money back? And from the big vendor, we got the money back. They still said they didn't agree with it, but they paid it. The little vendors just didn't. And the one said they would go out of business if they had to pay it back. And I think, and I don't know whatever happened. I wasn't very high on the totem pole at that time. So I wasn't in the loop in terms of what happened. So I don't know whether they went out of business, but I do know they're no longer in business now. So maybe they did. What is the purpose of this story? This hopefully illustrates the concept of things changing over time that require different approaches to procure and manage contracts, and especially that based upon what is happening under current contracts, that follow-up procurements are tweaked or even radically changed to try to improve results the next time. So that is the class, but we do have a couple what I think are important things in the appendices that I want to cover. And we will, I don't know if we'll finish this before lunch, we'll come back afterwards. We have a little exercise that we'll go through, and we'll probably end up early. And I know now if you complain and someone wants to stay and just have a nice friendly chat, we can do that, but we'll probably end up early. Question?
I have questions about the DHMH.
Okay.
When the proposals were done,
When we did it by sealed proposals?
Well, no, in the beginning,
Okay.
by the labor hours, when it was a labor hour
All right.
contract. And apparently they were meeting it not meeting the hours.
Right.
Now, was it because they was getting it clean because the staff was checking up to make sure they was doing things right, as opposed to what was different in the RFPs when I guess they were meeting it?
In the RFPs, we didn't specify.
Okay. Well, maybe when it went to just the bidding, the low bid. And I understand when, sure, you look at the low bid, but still you seem like you got to have still performance standards in there.
The standards of cleanliness were there.
You know, but it's still like it seemed like you got to check up on your contractors to make sure they're still doing things that they were supposed to.
Yes.
And I think the downfall on a lot of times of those labor hour contracts, it takes a lot of follow-up on the facility because you got to check. And obviously they wasn't checking that they was doing the hours, even though they were cleaning it, because nobody was checking up to making sure they was doing the hours, they was just approving the invoices,
Well,
it seems like.
the other thing that I cannot tell you whether was really happening was the evaluations were that the vendor was meeting standards. But I don't know whether the vendor actually was, or whether there's another situation where the state personnel were signing off even though the place wasn't really clean. Because that probably was happening as well. And sometimes there's this coziness that if there's a coziness between the state contract manager and the vendor, the state person might be signing off, and yet there still are complaints from the program people of why isn't this clean, things of that nature. But if you go to the records and the documentation, is that everything is fine. And that's what the contractors, despite whether they were or were not doing a good job, when the auditor said you have to pay back money, what they produced was documentation that consistently showed that the facilities were signing off that the work was as to standards. It may not have been.
Right. I mean, I still feel that they owe the money because it was in the contract, because they not only had to do the cleanliness, past the cleanliness, they had to provide the number of hours.
Well,
it was stated in the contract.
when we did it by sealed proposals, what we did was, instead of telling them the number of hours, we asked them to tell us. You tell us how many hours you will provide of direct labor hours and of supervisory hours. Justify why you think those hours are appropriate. And in those contracts, since with hindsight everything is perfect, we specifically said, now that you have said how many hours you will provide, when we award the contract to vendor A, both of those requirements, both the standards were required and the number of hours. And if you don't provide the number of hours, we will deduct. So if you don't meet the standards, you have to provide more to meet the standards, and if you meet the standards but don't provide the hours, we will deduct for it. So everyone was clearly on notice, and we didn't tell them. And I thought it was very ironic, well, not ironic, when I went back to my boss saying he went to two reputable vendors to set the standards. One of them was the vendor who was consistently underperforming, the big vendor that had to pay back most of the money. So obviously, even though this was a very trusted vendor, it wasn't a very trusted vendor because they apparently inflated the number of hours beyond what was necessary. Whether they did it deliberately or whether they didn't pay much attention to it since it meant nothing, that's what happened. You may make comments.
No, just two comments based on what you said. One is, I don't know how the invoice was supposed to have been presented. If I were the contractor doing the work, I would have presented the invoice as cleaning your facility, here are the dollars, not specifying the hours.
Yeah, there was a weekly amount, and that's what they bill for.
And that's what I would have billed for without specifying the hours. And then I would have pointed out to the state that, look, you make me responsible for more hours if the facility isn't clean. By the same token, I believe that if I'm able to become more efficient, or I pay people a higher wage and get better efficiencies, or if I have more supervision and that results in a better clean facility at lower cost to me, then as far as I'm concerned, this is a fixed price contract. Because remember, the type of contract wasn't specified, right? And that's the argument I would have made, and I would not have paid the money. But
Because I think even in a low bid, I mean, I tell vendors this all this time, because every time they think that, okay, I'm the low bid, then I'm the winner. I was like, no, there's still qualifications you have to meet.
Yeah.
You know, all the low bid means is I'm just going to evaluate you first, basically.
Okay.
And to see if you meet all the requirements in the solicitation. But I think even with the low bids, it still should have been something in the contract that said, if saying that you got to do cleaning between these hours and stuff like that.
Well, that was all there.
You know, just to make sure that if they clean between this time and this time, and hit all these floors or whatever in rooms, then okay, I believe that you did this, and you know, the floor's gotta be done this way and this way, stuff like that.
It gets back to the issue of what do you specify, the clarity of what you specify, and a standard that I use now, and I talk about in the planning class. For any piece of information in the document, ask yourself, what's the purpose of that information? For instance, now, if an agency would send me that same thing with specifying hours, first thing I'd say is, what happens if the vendor doesn't give you those hours? If the answer is, well, we deduct, I would say then you must tell the vendor clearly that that's going to be the situation. If the answer is, well, this is just for illustrative purposes, this is just to give them a general idea, well, then I would say one of two things. Either, well, then you have to say that, and the thing I think I would probably say is, then why do we put it in there at all? If a vendor's not going to be held to it, if it's not meaningful information, why do we, number one, have to give them some indication of what it potentially would be, because how accurate are we? And if we're not going to hold them to it, why put it in there? So what's the purpose? Is it a substantive issue? If it's substantive, then you deduct. If it's not substantive, then why was it there to begin with? And it's kind of like the premise you go by, for the most part, things are in specification for a reason. And although I know many times when you get right down to it and ask the question, why is it there, you get an answer, I don't know, it was just there before. But the basic assumption is things are there for a reason, and if they're there for a reason, then you apply what is appropriate. And again, I fortunately was not the boss at that time that I had to worry about the details of what was going to be the answer. And all I know is for a long period of time, there was issues. And the other thing I remember vividly is I said DBFP said all the future contracts had to be done on low bid basis. My boss didn't want to do it. He flatly refused to do a procurement on simply by give me a price. And so for a period of more than 6 months, I think close to a year, we had contracts that expired. At that time, DHMH had 26 facilities, and probably 10 or 12 of them had housekeeping contracts. And we started coming up with 4 or 5 or 6 contracts that expired, and because my boss would not agree to what he was being directed as far as how the new specifications were supposed to be, we didn't put out any new solicitations. We just let the contracts expire, and then the facilities just kept paying the bills, just kept the same contractors in place, paying the same amount of money without a contract. Now, currently we wouldn't even think of that, but back at this time, that's what happened. It was not a highly unusual situation that people would be working without contracts. This was before Title 21, well, probably was right after Title 21 went into effect. And I can remember at one point in time, the one budget analyst from DBFP, and at that time the budget analysts were like dictators. They were like brutal dictators. And they would tell agencies how they were going to operate, or else they were going to see the consequences in their appropriations. And I remember the one time the budget analyst who was in charge of DHMH went to the Assistant Secretary of Administration and told him point blank, you will get these contracts out, you will get them out the way I say, which is simply just low bid, and you'll get them out ASAP, or else here's what I'm going to cut from your budget. And so the Assistant Secretary said to the Director of Administration, do it. The Director of Administration told my boss, do it. My boss said he wasn't going to do it. And so the Director of Administration came to me, some just little guy, and said, you're going to work 6 days a week, maybe 7, until each of these contracts is redone and issued on this new basis. And your boss is out of the picture. You don't go to him, you report directly to me. You will tell me when these things are being done, and shortly after that, he found himself without 90% of his job duties.
With 100% of his pay.
Yes. So he went from having 30-some people report to him to having 3, me being one of them.
I like that. That's a very clever idea. I may have to try that.
And you reconstructed all the things that he used to have back then that he lost because of this little impasse of not doing what his boss told him to do. And all right, so that's more of the story. So let's see, appendices. Now here's something that you are not going to think of as contract management, but these are things that come up. They don't come up all the time, but they come up frequently enough that I felt necessary to at least tell you sort of what the rules are or the recommendations. And we will go through each of these. Sometimes for major contract awards, vendors may want or say they are required to do a press release announcing the award. Sometimes the vendor may even want to do a press release before the contract has been actually awarded, i.e. they get a recommendation for award and they want to do a press release because they want to brag. We won this major contract. The state, this wonderful entity that is so conscientious in procurement and so on top of things, kind of like the opposite of what we sometimes think we do. They want to use that for bragging rights of, if we can win the state, come one, come all, we can do your job too. So sometimes that happens. So the first issue is, and this is something recommending that you start doing this in your solicitations, for major solicitations. Obviously, if it's a simple courier contract, you probably don't have to worry about this, except maybe you have a standard clause that you're going to use, just period. But major when you might have a stipulation that the agency's contract manager must approve any press release or public notice of a contract award or recommendation for award, i.e. the vendor cannot do a press release without the state's prior written approval. Secondly, vendors should be discouraged from issuing a public notice of an award recommendation. So distinguish between an actual award, meaning after it goes to the Board of Public Works or whatever the final approval is, versus just the notification, you're the one that we are going to recommend, still have to get further approvals, but at least you know you're the one that has to sign the contract now. So the first thing is they should be told not to do anything when it's simply a recommendation, and when it goes to an award, if they feel they need to do something or want to, we have to approve it, and with the general discouragement from doing it. Recommendation should not be assumed it will automatically result in an award 99% of the time, or 99.999, that may be the case, but not necessarily always. Until there is a formal approval or recommendation, there is no award. Premature notices should be avoided. This is also why this issue is being discussed in perform rather than procure, because it's after there is an award. However, a vendor recommended, this is a wrinkle, and this is one I experienced 4 years ago. A vendor recommended for an award may say immediate public notice required by the Sarbanes-Oxley Act of 2002. That was one where there was all the accusations of insider trading and vendors doing things when they knew it was giving information in a positive fashion would likely result in stock prices going up, and so there were some companies that were manipulating their stock and manipulating actions to maximize returns as a consequence of the Enron and WorldCom and a few other things. Sarbanes-Oxley happened, and so back in 4 years ago for the pharmacy contract that you're currently enjoying right now, the vendor Catalyst said that as soon as we made the recommendation that they were required under Sarbanes-Oxley to provide notice of this. Because what they said is if they sold any stock, if the principals of the company did anything of that nature, they could be accused of insider trading, and they needed to get notice out so they would be protected from anything they were trying to do. And so the first thing we did, and our Sarbanes-Oxley only applies to public companies, not private ones, so this was a public company. So this is what I said here. They can be accused of violation. Any claim that immediate public notice of a recommended award must be made should be referred to your Assistant Attorney General. Number one, legitimacy. And in this case, 4 years ago, our assistant AG talked to the lawyer for the company and said, why do you think you're supposed to provide this notice? The lawyer explained it. Our lawyer went and looked under Sarbanes-Oxley, a specific section that was referenced, and our lawyer agreed, yes, I agree that under this they are required to provide a notice, that they could be subject to sanctions, to lawsuits or whatever. Now that they know they are supposedly going to get this award, that until such time as they published a carefully crafted notice, they are subject to possible legal action later on if it's known that they knew for some period of time they were likely to get this. So once our lawyer said that she agreed that they had to do something, then the issue became, well, what kind of notice will we allow them to put out? One that we agree meets the requirements but doesn't go beyond it, doesn't become bragging, doesn't put down another vendor, the incumbent who wasn't selected, things of this nature. So this is what we're telling you. If a vendor ever comes to you and says this is a situation, you're going to go to your lawyer and ask your lawyer what to do. The public notice approval requirement applies for notice of an award or recommended award. The agency needs to see and approve in advance the wording of any public notice. In particular, the agency should ensure that notice does not directly or indirectly negatively reference any other offer. And I remember the first draft of this one newsletter was, if you can put it this way, bragging that they had unseated a 12-year incumbent, which the vendor was here for 12 years, and basically laid it on very heavy. Here they had this vendor that had been here for 12 years, and they came in and blew him out of the water, and they basically were, by inference, were negatively making aspersions on the incumbent. So we had them take out anything of that nature, and just very straight and simple. Is recommended for award of this contract still subject to approval without any notice of how many vendors there were, because what they said was, because at this time you have the register of proposals, so they knew how many offerors had responded. So they had bested 5 other offerors, including an incumbent who had been on the job for 12 years, and these were the giants of the industry, and they had come in as a relative startup and a very small company and displaced the 3 largest vendors in the industry, including the 12-year incumbent, and it was laying it on heavy, and we just said, no, just, you've been recommended for award, still subject to approval. So we had no inference one way or the other on other vendors, such as the incumbent, what I just said. And in this, many times you're winning because of price, so any inference on the quality of another vendor is inappropriate. For a major contract, the awarded vendor or the vendor recommended for award should be reminded of the requirement for prior approval if it wants to release a public notice. If there is no provision in the solicitation or contract for prior approval, the contractor or recommended offer should be told that prior approval is required. So even if you don't have a contract requirement, when you give them the notification of award, if you even have an inkling that they might want to do this, you can just bring it up. Now, I'm not saying you will want to do a press release, but if you do, you need to come to us first. Or if you get to a work initiation conference, that can be an issue. So let them know that it's not something they can do on their own. And most of the time, vendors don't do that. But if it's really a large contract, they will want to get some kind of notice out there. And even if you don't have a contract requirement and you say, we want you to come to us anyway, there's no reason why they shouldn't. It's not a cost issue. It's just something that they should be cooperative. And it's something that you can tell them, that if you tell them to get your approval and they don't, and they publish something that you think is incorrect, you would be forced to issue your own release to correct the inaccuracies. And obviously that's not a good thing if a vendor does a release and then the person that just hired them has to do a counter release to say, wait a minute, you've kind of distorted the facts a little bit, so here we need to correct the record, so you can warn them of that. And that's the one thing. And if you tell them not to release it without your approval, and they do, then you tell them that that's not getting off on a very good foot with abiding by the wishes of the agency. That's not the way to set up a relationship, that you ignore what we want, and so you tell them those things that should dissuade them from doing something without your approval. If they did this anyway, if there was a contract provision that they didn't abide by it, you would not terminate the contract for that. You would not seek to invoke any liquidated damages, but you will tell them that does not bode well for compliance and for good relationship, that it probably will prompt you, now that you know from the very beginning they've ignored something you told them that shouldn't happen. Well, we're going to have to start from the very beginning and be very, very diligent in monitoring your contract, because if you've already, for something simple, not abided by what you were told to do, we have to be on top of you all the way, and it's because we told you not to do something and you did it, so we got to nip this in the bud. And the reason is because they violated something that they were told not to do. Now, so that's press releases, and probably none of you might have had that situation, and I've had it a couple times, but it didn't really hit home until 4 years ago, till we had this major impasse over Sarbanes-Oxley, and after, I think it took us 2 days or so to finally get to the point of agreeing what they could put out, and they were really nervous. They were coming to our lawyer all the time of, we got to get this notice out. You know, for each hour that passes that we don't get a notice out, in the future somebody could come back at us, because the stock is constantly being traded. So even if the company itself doesn't do anything, other people are buying and selling its stock, and if they knew something that was not publicly disclosed, they would say at some time in the future, somebody who bought or sold could come back and try and sue them, because they did not release information that had a significant impact on the value of the stock. So even in this case, 2 or 3 days was something that they thought was very critical and really an issue, and they were coming back a couple times a day with, can we release this? Can we release this? So, one situation. Another situation which has happened to me and may happen to you, and that's when the contractor sponsors events. And to what degree can you, as a contract manager, participate in these events? After a contract commences, the agency contract manager and maybe other agency personnel may find themselves invited to seminars sponsored by the contractor, trade shows, exhibits, etc., where the contractor comes in and says, here, we have an exhibit down at the convention center, and it's normally $10 to get in, but here's 2 complimentary tickets. I'm giving all my customers, and you can come in, you can go through, and we're in booth number 78. Come by and see us, and we have goodies that we give out at the booth and stuff like that. So the question is, can you take up on what the vendor is offering? Is it okay to attend such events? The general rule is that if an event is not specifically created for your benefit, it may be okay to attend under the following circumstances. If there is something at the convention center, and if they are an exhibitor, and whereas they can invite anybody and everybody they want, and they can give out free tickets if they want, then it might be okay. But here's the additional caveats. Are more than just the agency's personnel expected to attend? I.e., is it more than just for you? Is the event held locally with the agency reimbursing its personnel for the expenses? If you go, do you pay for your own parking and get reimbursed? If they don't give you free tickets, are you paying for your own tickets and you get reimbursed, things of this nature? Do you pay for, if you buy snacks or whatever, is that on your dime? So that's part of the question. If it's not locally, then, well, let's go to the next one. Is the event constructively educational in nature and not simply a thinly veiled attempt to buy business through meals, giveaway, and items of value? In other words, how informative does it seem like this exhibit or this seminar is, versus just that we're trying to give away junkets and we're using the excuse of a seminar to just kind of give away goodies that hopefully you will remember us in the future. then this is something that's kind of in regulation. Is the value of meals, snacks, etc. provided at the event relatively inexpensive? And inexpensive is generally defined as $20 or less. If what you're getting is generally $20 or less, then generally it's okay. If it's more than $20, then you have another consideration. Depending on the answers to the questions in the prior slides, it may be okay to attend the event, but before attending an event, consult with your own ethics policy and your people in charge of ethics in your agency. What is your own policy about these types of things? Maybe your assistant AG, and maybe even the State Ethics Commission, because you can frequently do an informal inquiry to the Ethics Commission and they can give you an informal answer. So that's if you have contractor-sponsored events. Meetings at the contractor's office. When attending meetings, inspections, etc. at a location of the contractor should be dissuaded from providing inexpensive meals or any type of gift for state personnel. See slide 15, which now is slide 854. This was done as a standalone presentation, so that needs to be adjusted. Soft drinks, light refreshments, etc. may be okay. This is most likely to occur if the attendance will extend both before and after lunch. So number one, if you're going to the vendor's location, try not to go over lunch. Or one thing that I have done when it was unavoidable, you're basically there the whole day, tell them in advance, either don't do anything for us, we'll take care of it ourselves, or something else I have done is when the vendors said that they would have takeout, they would order stuff in and was asking what you wanted and offering to pay, we would say, well, fine, yes, we will give us the menu, we will order something, but we will pay you for what we order. So a general rule, you don't take anything from a vendor, especially anything that is potentially more than $20. Gifts. Gifts for state employees are discussed in 15505 of the state government article. Section 15 of the state government article deals with public ethics. So you're doing, not in the state finance and procurement, but you're in the state government article. And per 15505A, state employees may not solicit gifts. You may not ask for gifts. State employee may not accept unsolicited gifts from an entity that does or seeks to do business with an employee's government unit unless the gift would not tend to impair the impartiality and independent judgment of the employee. So that is a quote from 15505B1 and 15505C1 small 1. That's what this says. May not solicit, and then unless would not tend to impair the impartiality and independent judgment. And most people would say, well, even if I get a gift of $50, I'm not about to award contracts on the basis of $50 or something like that. So theoretically, maybe you could take something more than $20 in value because you claim it would not impair your impartiality and independent judgment. But the bottom line I say is just don't take anything, and then you don't have the issue as to whether anybody can make the claim that it impaired your judgment and they basically bought you off. So you cannot ask for anything, and you cannot take it even if you didn't ask for it if it doesn't meet these circumstances. Cleanest answer, don't take it. Now this also becomes an issue, and this is going to be expanded a little bit in the future. If you're having events, and sometimes we think it's okay to go to our contractors to ask them to sponsor events. We're going to have a kickoff meeting and we'd like to, for this new contract, and let's say there's 5 vendors on a master contract, and we'd like to have all the state agency personnel come in to find out about the new contract, get to meet you as the contractor, and we want to provide some refreshments as an inducement for the agency personnel to come in. And so we'd like each of the contractors to kick in maybe $50 or $100 to pay for the expense of these nice little, I can't even think of the word, the soft drinks, the little things, the meals and stuff, and little door prizes. And basically, under this situation, you're not supposed to do that. You're not supposed to ever go to a contractor and ask them for a gift, whether it's directly or whether it's to support something of that nature. So, and I know that has happened and it has caused some problems at times. If a contractor inquires if the agency's contract manager or other state personnel can or will accept gifts, except for gifts that would not tend to impair the impartiality and independent judgment of the employee, the answer should be no. And I go even further, no. The answer is no, don't give me anything, I don't want to take anything. If a contractor does not ask in advance and simply sends a gift, if the gift would not tend to impair the impartiality and independent judgment of the employee, it is probably okay to keep the gift. If the gift is of significant value, over $20, and or would tend to impair the impartiality and independent judgment of the employee, it should be returned and the contractor told not to send such gifts again. If they send you a calendar in the mail that you know is probably worth 50 cents, probably not a big issue. If they send you a nice gold watch for a Christmas present that you've seen in Nordstrom's for a couple hundred, you may want to send it back and say, don't do that. Now, I've never had anyone try and give me $200, but so that's the thing on gifts. Endorsements. This is another thing that can come up during the course of a contract. And I will cover this, then we'll take a break, then we'll go to lunch. Generally, the state does not endorse any vendor's product or service, even if you are very satisfied with the vendor's work. If a contractor asks for some type of endorsement, generally the answer should be no. This is especially true if there is an offer of payment for your troubles, and we'll give you a $20 gift certificate if you go ahead and give us this endorsement. Or it is stated that this endorsement, we will publish this endorsement, and by this endorsement being out there, published near and wide in businesses and newspapers, and it'll be listed who is giving us this endorsement. So obviously you will be viewed as an important person in this industry by the fact we're publishing your endorsement. And so don't you want to get your name in the paper and in the magazine as being a well-known expert in this field? Answer is no, you shouldn't do it. Again, refer to your agency's policy on such matters, your assistant AG or the Ethics Commission. Let's see. One more slide, then break. What if a vendor asked to use a letter of praise you had previously sent to it in an advertisement or some other publicly related fashion? And we have said earlier in this class that letters of praise may be a valuable inducement to a vendor to do a good job, because they want to be able to show other prospective customers that they have people saying they are doing a good job. And so what if you have done this simply because they've done something above and beyond the call of duty, and you want to acknowledge they've done a good job and you want to praise them, and now they come back to you and say, can I take this and can I put this in an advertisement? So basically it's the same issue. There should be a clause in the solicitation or contract, so this is a suggestion that you build in such a clause, that requires the agency's permission to use any communications with the contractor in any context except for internal contractor purposes, and with or without such a clause, seek guidance from agency policy, assistant AG, ethics commission, etc., concerning such a request. So with that, go to lunch, come back, we will continue on these and a couple other things.